Constitutional Reflections on COVID-19 in Argentina. In the last 100 years, we have lived from emergency to emergency with the deep violations of the Republican and federal system and individual rights and guarantees. Regarding the emergencies, it is necessary to say, first, there are exceptional situations that affect the constitutional order. Second, they can be originated from various causes, political, economic, social, or natural. Third, to face them, the law creates various emergency institutions. Fourth, they produce an increase of power in the executive, but with the control of the legislative and judicial powers. Fifth, the emergency produces restrictions in the fundamental rights. And sixth, there must be a true state of necessity. In Argentina, we have classified the institutes of emergency in established, prohibited, and not established by the Constitution. Regarding the first institutes, a distinction must be made between those existing since the original Constitution of 1853, the federal intervention, and the state of siege, and those incorporated in the 1994 reform, the legislative delegation, and the decrees of necessity and urgency. The institutes prohibited by Article 29 are the sum of public power and the granting of extraordinary powers to the president and governors. And among other institutes not established by the Constitution are the interruptions of the constitutional order by the de facto governments, martial law, etc., that produced the most severe injuries to the rule of law. And the same happened after the 1994 constitutional reform with the abuse of the legislative delegations and the decrees of necessity and urgency as institutes of restrictive, limited, and exceptional interpretation. All this was deepening the weakness of the constitutional and legal culture, the low institutional quality, and the hyper-presidentialism that characterize Argentina. In this context, I published an article in Clarín Journal, Buenos Aires, on March 23rd. In the face of COVID-19, the President of the Republic, with the support of legislative authorities and governors of different political signs, announced the decree of necessity and urgency, which introduced the lockdown. Later, the President explained that the declaration of the state of siege was not necessary. This attitude of national union and of prudent and strict application of the national constitution in that moment must be highlighted. And I said, it is time to hold on to the Constitution as an architectural policy based on its democratic, republican, and federal principles. But on April 24th, I wrote in the same journal, almost 30 days after those first measures that showed a plausible attitude with an adequate communication from the President and agreement of the opposition, we must now express that the institutional reality indicates otherwise. We are governed by president's decrees and resolutions and by very few people, as it happened in the past. The Congress is not in session, and the judicial power acts in a limited way because an extraordinary judicial recess has been declared by the Supreme Court of Justice of the nation and the superior tribunals of the provinces. Consequently, there are not adequate controls on the various emergency measures which are affecting individual rights. We have returned to the hyper-presidentialism without respect for the Republican and federal system. Congress is not complying with the constitutional obligation for the control of the emergency institutes. The president acts with huge centralization because we must bear in mind that in this health emergency, the competencies correspond concurrently to the four government orders: federal government, provinces, autonomous city of Buenos Aires, and municipalities. I believe that the federation as a system of state and government has been very important at this time, as other examples in comparative law also indicate, particularly Germany, where its efficiency was highlighted based on Merkel's agreements with the Länder heads of government for major decisions, while their execution corresponded to the Länder and municipality. Finally, this COVID-19 has presented us with two great options as expressed by the professors Harari and Chul-An. First, the solidarity and multilateral actions through the United Nations and regional organizations, or the unilateral action of each state. And the second option, between the responses of democratic regimes or those of autocratic or totalitarian systems. For its part, the International Association of Constitutional Law organized, together with the Argentine Association of Constitutional Law, a roundtable on constitutionalism in times of emergency in Córdoba in 2005. The first panel considered the following topic: Schmidt versus Dicey. Are state of emergency inside or outside the legal order? To promote a debate on philosophical and constitutional aspects of a state of emergency. Schmidt represented the autocratic or totalitarian response, and Dicey the opposite. The English professor said that rule by law and rule of law are both sides of the same coin. I insist that the emergency is not above the Constitution. This is what differentiates democracies from autocracies. I believe that the answer is to embrace the great values of constitutionalism and humanism with a permanent fight for democracy, freedom, and human dignity. Take into account the actual hard situation of democracy, according to Professors Levitsky and Sivlat, in How Democracies Die, and Larry Diamond in Ill Winds. Finally, dear Jim Garner's students, do not forget the Madison statement: the concentration of only powers in only one head is the very definition of tyranny. Thank you very much.